everybody else is muted. That's good. Barbara, welcome back, Barbara. All right, Susan, I've got you, your voice. Did you get that document?
Adults will have some sort of edema in their legs, while other studies will say that 1 out of every 2 adults. What is that?
I'm not sure. I heard something play in the background.
Yeah. Okay. Now I'm on, so I don't have to do the Zoom. Oh, no. Let's do that.
Yep, I can hear you here, and it sounds clean, so we're good.
Okay, I just had to minimize certain things on my screen so that I can see you guys. And I do have 4 pages.
4.
It's printed.
Oh yeah, 4. Yeah, 4. Looks like 4 printed. Yeah. Yep. That's what it is.
And you didn't number your pages.
No, I didn't.
Pain in the butt. Okay.
I numbered mine.
Okay. Yeah. That was kind of started out informal. So yeah, it looks like I missed something there.
I'm just telling you, from the side, receiving side.
Thank you very much for that. You know, we'll it helps because, you know, I make mistakes, and that's why we need a team, right? Jeez, my goodness. Yeah, it'll help because this.
I'm not the editor. I'm just responding so that in the future you might think about it.
Exactly. Awesome. Thank you for catching that. As we move forward, we're gonna, you know, be using this as a, you know, the beginning of a template, so we'll have smoother things going forward too. So, okay.
Can you hear me okay?
Yes.
Okay, great.
Is everybody here, Susan, all right?
Yep.
Okay, I'm going to turn my volume up a little bit here.
Yes, I can hear too.
Okay, great. Sounds nice and clean on my side. Jeanette, Will and Curtis, we have no video. For the jurors, we have to have our video be professional. We don't want to be eating up and down, walking around, lots of things, people walking around, that kind of stuff. The jurors need to be visual. We don't want to be eating and cleaning tables and, you know. We do kind of want to make this...
convened as a jury.
Yes. We're not we're not at the park having a picnic, okay? So yeah, we want to have this as professional as possible. Can we do a sound check over there, please? It looks like we have 1, 2, 3, 4. I can't really see Paul. I see the back of his head. So we'll need to, you know, the jury members, we're going to need your attention. And we got somebody in the background. I'm not sure who that is walking around, but.
Florida.
Okay. Yeah, let's clean up the visual there because this is a professional recording here. We're gonna be putting out to the public as well. Okay, I can barely see you, Jeanette. I don't see it because the name actually covers your face. So yeah.
I know.
Yeah, if you're back like that, then I can see you guys now. Everybody speak or one at a time. Say hello or present. Or I'm going to call your names. Curtis, Timothy Keller.
Present.
Willie Allen Jones Jr.
Present.
Paul James Cupper.
Present.
John Lumiere wins.
I'm here.
And then, okay, so that's the 5 that we have there, right? Okay, good. All right. Let me check. So we have all the officers. I think we do. And what time is it? 9:53. Okay. Barbara, you've got that in front of you. Looks pretty straightforward, yeah?
Yeah. And also it's to allow her to, for remedy and relief. There are 2 issues it's not all remedy. There's remedy and relief. Those are two issues for a jury.
Okay, so you're going to bring that up to the jury?
Yes, I am.
Okay. And yeah, where do you, yeah, I'll let you handle that. We'll have to fix this document after.
No, it's okay. It's just that most people think, well, I'm going in for remedy, but it's remedy and relief. And those two have specific purposes and intent and definitions.
Okay, thank you. All right. There is one thing I want to change on mine. Let's see, where are you? That's,
Tony.
yes.
So, are we, is my understanding that she was asking for a declaratory judgment? Is that changing?
Who is speaking?
This is Willie.
Willie, yes, we already covered all of this in the jury pool. She is seeking, based on the merits of facts and evidence.
She wants a judgment on the facts based upon the evidence. She wants it found on the facts and the merits of the case.
Yeah. And this, she will present this again. You know, that's up to the claimant to, in her presentation to the jury, and she will state what she's expecting for findings and so on.
Well,
Okay,
I'd like to explain something. Okay, we're doing this according to Article 3, which set up the courts for the states, the de jure states. Okay, and it's defined in Amendment 7 to the Bill of Rights. Okay, and so what that says is any fact is found by this court cannot be reviewed by any other court. So this is over a year's work, and this is the culmination of that, laying this out and putting all of these facts in evidence, okay, on the public record. So what we want is a judgment, a finding of the facts, because those facts are set in stone from that point on, okay? And then we want it on the merits of the case. We want to try this case. We don't want a summary judgment or a declaratory judgment or anything like that. We want a judgment on the facts and merits of the case and any other relief as this court finds appropriate. Thank you. I yield.
Okay, thank you for that, Doug. All right, everybody should be muted now. We have some the general public entering. We have quite a few in here at the moment. So let me see. I've got, yeah. All
So
right.
you did open this to the public, so anybody else can come in and watch.
That is correct.
Great.
Yeah, it's a public. You know, our courts are open to the public, so yes.
Okay.
And let's see here. Oh, good. Maybe I can do that. All right.
Yeah, this is coming from Ian.
Oh, I see. It's working because it shows up on us on the screen. That's all I'm saying.
Yeah,
Oh, I see.
I don't see you guys over there, Paul. You know, right now I just seeing your nameplate.
We're having technical difficulties.
We're in another location.
Yeah, towards the bottom.
Well, it might not
Yeah,
be
no.
toward the
Sorry,
bottom.
I had to reconnect to the network to get a secure connection.
Okay, let me know when you're ready. Right now we've got about 2 minutes before we hit 10 a.m. And when you guys are ready, let me know so that I know when to open the court.
Tony, do we also have the witnesses? Do we have Susanna and Paul Gilbert? Or are they coming in at 10?
I don't see Susanna, nor do I see Paul Gilbert.
I'll probably check in.
Did you invite them?
Yes.
Lenka?
Yes.
Yes, they'll be here.
Okay.
Paul Gilbert is there?
Not yet.
Okay, let me text Susanna.
So we'll be waiting for them to get on as well before we open the court.
Yeah, he's,
You might have
And
to,
this might be a stupid thing to ask you guys. Say it was 10:05. Should we say 10:05 since O is a letter? I don't know why. That just seemed
Yeah,
weird to me.
you could say 10:05.
Okay. I like that better.
California Daylight Savings Time.
yes, California did savings time.
Well, yeah, we were just going to say Pacific Standard Time. Yeah.
It's not standard.
It's not standard.
She's the one who talks, not you.
Well, nobody else.
Okay.
Hey, Tony,
Yes, ma'am.
you did a really good job. I just want you to know I really appreciate your efforts. You did a good job.
Oh, thank you very much. Everybody hear that? That's my good job for the day.
You're not finished yet. You're not finished. Keep on going.
By the end of the day, she might retract that. So I want to make sure we get it on the record. Do we
Put that on
record
the-
that?
put that on the record.
All right. Let's see. It is so we are going to for the general public that's on the call right now as the acting de jure sheriff for Nevada County in this court. We are awaiting some witnesses to get online here and become part of the court before we can actually start. I know it's
You
10.
don't need to wait for them. But
You don't have to wait for the witnesses.
texting them right now.
She's texting them and they can pop in, as long as they get here before it's time for them to testify.
Okay. All right. So,
An update on Paul Gilbert. He's walking up the stairs. He'll be here in a minute.
okay,
Oh, fantastic. I was just about to text him, so that saves my text. Thank you, Paul.
Okay. So what we're going to do is Susan, I'm going to mute you. And then I'll have everybody muted. Everybody should be muted right now. The general public should be muted. Okay, so now let me get this thing here. And we're going to start the recording. We're going to start the recording now.
Recording in progress.
Okay, recording is in progress, and I'm going to go ahead and open the court. I, Anthony Louis Franquito, as acting Nevada County Sheriff for Lenka Coloma's Court of Record, our one Supreme Court in law, public of the United States of America, on the County of San Luis Obispo, as source of Article 3 jurisdiction affirmed by the 10th Circuit Court. And for the record and on the record, notice officers, agents of the United States. These proceedings and presentments are not intended to harass, intimidate, offend, conspire, blackmail, coerce, or cause anxiety, alarm, or distress. Pardon me just a moment. Somebody has their mic on, please turn it off. Please mute your microphone. Thank you. All right, hang on. I'll mute it. Okay. I'll state this for the record one more time. For the record and on the record, notice to officers, agents of the United States. The proceedings and presentments are not intended to harass, intimidate, offend, conspire, blackmail, coerce, or cause anxiety, alarm, or distress. They are presented pursuant to the lawful authority to facilitate stated intentions to achieve honorable settlement. Any affirmation contrary to the stated intention will comprise your stipulation to committing a fraud upon the court. The rules of the court are one man or one woman shall speak at a time. I will be doing the technical aspects of this, muting and unmuting, and bear with me as we go through it. All people will be muted and unmuted when needed to speak. All officers, claimants, and respondents or agents shall be have their video on the entire time the court is in session. People on the video are to avoid having distractions in the video, such as dogs, cats walking around, doing other things and eating and so on. Okay. Now, as acting sheriff for this court, I shall now bring in the jury. When I call your name, please raise your hand and give me a here or a present. Let me know that you're here. Foreman for the jury, Jeanette Harden Wadlow. See your hand raised, and let me go ahead. I want to get your voice for the record, so please turn on your microphone.
Here.
I've got a massive echo coming back at us. Can you correct that? Okay, next, Curtis Timothy Keller.
Here.
Thank you. Willie Allen Jones Jr.
Here.
Paul James Kabak.
Yeah.
John Lumiere Wins.
Here.
Thank you. You can turn off your mic over there now. Thank you. Jana Wright Izotov.
Present.
Thank you. Todd Allen Mitchell.
Present.
Lori Diane Mitchell.
Present.
Thank you. Darcy Diane Raymer.
Present.
Thank you. Brianna Jaden Need.
Present.
Sandra Marie Casiato.
Present.
Thank you. Melissa Ann Nicole Peters. Alternate.
Present.
Pamela Joan Parker Papa. Alternate.
Present.
Thank you. Okay. Is the claimant Lenka Coloma present and accept the jury?
Yes, I'm present and I do accept. Thank you.
Thank you. Is the respondent or respondent's agents present? If the respondent's agents, let me do this again. If the respondent or respondent's agents are not present, they waive their right to speak and present evidence in this matter. For the second time, is the respondent or respondent's agents present? I'm checking the screens. I'm looking through. I don't see any hands raised. I don't see anything in the chat. Okay. For the third and final time, is a respondent and respondent's agents present?
Tony, could you please state their name for the record?
I will do that in a moment. Thank you, Lenka. Okay. I, Anthony Louis Franquito, as acting de jure sheriff, served the respondent Stanley C. Middleman Friedman Mortgage, sent registered and signature return receipt September 8th, 2023. Received by the respondents September the 18th, 2023 at 1:58 p.m., signed by Otis King. And I also served the respondent's registered agent for Friedman Mortgage, Harry L. Hathaway, sent registered mail and signature return receipt September the 8th, 2023. Received by the agent September 11th, 2023, signed by Jessica. The respondent and or respondent's agents are not present and waive their right to speak and present evidence in this matter. I release the court to the acting sheriff. Excuse me, now I release the court to the acting court clerk.
Thank you. I, Tammy Stewart Vieira, as acting court clerk, convene the court session and affirm all are present, except the respondents who chose not to appear, and waive their right to speak and present evidence in this matter. Our one Supreme Court in law, Republic of the United States of America, on San Luis Obispo County, as source of Article 3 jurisdiction, affirmed by the 10th Circuit Court, and I, Tammy Stewart Vieira, as acting court clerk of our one Supreme Court, does convene and open this session on October 14th, 2023 at 10:10 a.m. Pacific Standard Time, and accepts 21 silver dollars to bond the case from Lenka, and affirm all elements required for this hearing are complete. And I, Tammy Stewart Vieira, as acting court clerk, makes this recording and notices that all others are responsible for keeping their own records. And I, Tammy Stewart Vieira, as acting court clerk, does hereby confirm the appointment by Lenka that Barbara Susan is presiding acting justice, who shall confirm the jury as follows. Barbara, you may proceed.
Let's see. I am asking to unmute. There you go.
Okay. The purpose and intent of this hearing is to support Lenka and provide the opportunity to exercise her right to have her issues heard by a jury of her peers for remedy and relief. I, Barbara Susan, appointed and acting justice, does invoke the following. Jurors commit to hear facts, law, evidence, testimony, and render a determination on the truth of this matter. And you and each of you do solemnly aver to assert or affirm with confidence, declare in a positive or peremptory manner that you will well and truly hear the facts, evidence, and testimony in this case, and a true verdict render. When you as a juror take this solemn commitment, you have to decide every question of fact in the case. It is your duty to act fairly and impartially. You are not to base your decisions on feelings or emotions, but reason and judgment and according to the law. You are not, however, expected to set aside your life experience and common sense as a juror. Remember, your task as a juror is to determine the correct facts of each dispute between the parties. Therefore, your service as a jury member is extremely important. As long as you perform this duty to the best of your ability and make an honest, careful, and deliberate decision, the American system of justice will be served.
And the juror members can unmute and state, I do affirm.
I do affirm.
I do.
I do.
I do.
Do affirm.
I do affirm.
I do affirm.
I do affirm.
I do affirm. I do affirm.
Okay, that's everybody of the jury has affirmed. Thank you.
And I will release the court to the claimant, Lenka.
Well, good morning, ladies and gentlemen of the jury. It's a great pleasure to be here with all of you on this lovely morning of October 14, 2023. Thank you so much for your time and trouble on my behalf. I am Lenka of the lawful family Coloma, woman, Californian, and one of the people exercising my right to remedy through this Article 3 Court of Record as defined under the 7th Amendment to Bill of Rights 1791. I am here today now to prosecute this case by bringing forth the evidence and proof that common law trespasses have been committed against me, which affect community at large. Before we proceed, it's also very important that we define definitions, as we have general definitions and specific definitions, such as legal definitions. And since we are dealing with the law, it's very important that we clarify these definitions, as we will be using them throughout this case to ensure that we have the meeting of the mind and there is no confusion or anyone thinking something different. So what I'm using is Black's Law Dictionary, 4th edition. And first, we will define 4 definitions. So the first one is loan, the meaning of the loan, which can be found on page 1085, which reads, lending also means advance of money with an absolute promise to repay, Bankers Mortgage Corporation versus Commissioners of Internal Revenue, and bailment without reward, consisting of the delivery of an article by the owner to another person to be used by the latter gratuitously and returned either in specie or in kind. So what loan means is if you loaned me $100, something worth of asset or value, like in something that's backed by something, I am promising back to repay you back. So there has to be something of substance value of yours given to me that I take full possession, and then promise to repay back to you. The next definition we need to confirm and define is money. What is really money? Which can be found on page 1157 in and it reads, in usual and ordinary exception, it means gold, silver, or paper money used as circulating medium of exchange and does not embrace bonds, notes, evidence of debt, or other personal or real estate. Lane versus Riley, 280 KY. So money, as we said, is something of substance, something tangible, such as gold and silver, something that has a value. It's not something made up, something illusionary. Next one that we will cover is fraud. There are 2 types of fraud, either factual or constructive fraud. Today, we will focus on constructive fraud that is defined on page 789. Constructive fraud consists in any act of a commission or omission contrary to legal or equitable duty, trust, or confidence justly reposed, which is contrary to good conscience and operates to the injury of another. Or, as otherwise defined, it is an act, statement, or omission that operates as a virtual fraud on an individual, or which, if generally permitted, would be prejudicial to the public welfare and yet may have been unconnected with any selfish or evil design. Or according to Story, constructive frauds are such as acts as contracts, though not originating in any actual evil design or contrivance to perpetrate a positive fraud or injury upon another person's, or to violate private or public confidence, or to impair or to injure the public interest deemed equally reprehensible with actual fraud. Story section 258. So constructive fraud is it means that if something it means that if something is looking that it's fine, that it's legitimate, that it's perfectly fine, but it's constructed on fraud, in that case we do not have to prove the intent, because
fraud's built into
fraud is basically built into that action. Okay,
such as you find out the whole system today is built on constructive fraud. It's built upon an unauthorized act of Congress back in 1933. It changed our monetary system without our knowledge and consent, and it revenued us into a basically fictional territorial venue, and they've kept us there ever since. So, being that it was an unauthorized act of Congress that changed our monetary system and allowed these people to operate in a voluntary bankruptcy, what happened is they set up a whole system to where there's no substance behind it, which it impaired every contract after that, because to have a contract, you have to have substance for substance, and there's a whole lot that goes with it. But that's the fraud that this whole system is constructed on. And this system is by the Bar Association, was set up to parasite off the people, and it really just sucks our energy, and we have no money because of this. So this whole system is constructive fraud because it's constructed on that unauthorized act of Congress and the taking of our monetary value or the substance from our monetary system and changing it. I yield.
Thank you so much, Doug. And also for the record, this is Douglas William Heisel, who is also functioning as my next friend in this case. So the last definition.
Can I make a comment?
Yes.
Okay. When they altered the American monetary system, it was done through an act where they loaned, they removed the substance from our currency, and they made a loan to European right after the war. And they loaned it out to them expecting a return with interest, and we're supposed to get those returns. That's why 44 federal judges sued Congress, because they didn't get the exchange rate that we're supposed to have because of that act. And I want to insert that in here because that is what you're talking about. The constructive fraud is it's based upon an underlying fraud, and we don't see it. But when you actually discover the elements of it, we have they shifted us into maritime jurisdiction. And that is where we have to, we can do some of our remedy. And this is one of those remedies, is using a court of record.
Okay, for the record, who was that was speaking?
Susan.
Justice Susan.
Acting Justice Susan.
Acting Justice.
Yes.
Acting Justice Susan. Okay.
Not Barbara Susan. Yeah,
Acting Justice Barbara Susan. Thank you.
Thank you so much. So the last definition we will cover is chain conspiracy, which can be found on page 383. Conspiracy may be continuing one. Actors may drop out and other drop in. The details of operation may change from time to time. The members need not to know each other or the part played by others. A member need not know all the details of the plan or the operation. He must, however, know the purpose of the conspiracy and agree to become a party to a plan to effectuate that purpose. Craig versus United States. So chain conspiracy means that we have many different players, many different layers, and they all play part in this constructive fraud. And without them, this fraud wouldn't be able to proceed. So this is what I will be showing you, where we are dealing with chain conspiracy here in this case. So now I would like to proceed to my court of record. We, the people, are the holders of all political powers. It was we, the people, that created the court system, and through our power and through our authority. We, the people, cannot delegate the power and authority that we do not hold individually. Therefore, we hold our private court of record when we prosecute our claims and trespasses through our private administrative process, where the public record either acquits or convicts the wrongdoers, and in this case, you, the jury, are the judge. So without further delay, we will be now proceeding to my court of record, which is a work of several months. And it started, so the whole case started in January of 2004. And also for the record, I would like to state that I made a mistake. Instead of 2004, I put in a statement 2024. I apologize for that mistake. I am a living woman who does make mistakes. I am not perfect computer. So this proves that I'm a living woman who makes mistakes, and I'm correcting it for the record. So my statement says 2024, but it should be 2004, and I apologize for that. So in around January 2004, I and my family, we were purchasing a home, a private dwelling, private property, land, and I was working with a real estate agent who took me and showed me and our family this beautiful house. We walked the land. I touched the trees. I touched the fence. I smelled the flowers. I walked into the house and I said, yes, I love it. I would like to buy it. So they said, great. So we went through the escrow process, and some 30 days later, I walked out with a grant deed, which is in attachment U in my court of record, and it stated that I am a joint tenant. And it really kind of raised an alarm. So I went back to the agent and I said, what does it mean that I am a joint tenant? And they all told me, oh, don't worry, it's all good. This is how it's done. But I did worry. So I did research. I spent a tremendous time and trouble going through history, what really happened, what's really going on. So it took many, many years for me to discover really the fraud that's been created. That it was truly a bait and switch. That this realtor took me to show me the actual land, the actual private property dwelling, but then at the end of escrow, they turn it into an overlay that was created to basically put this property into the assessor's map, create an APN, a parcel number, assessor's parcel number, and that's what goes into the final sale. So that's how the constructive fraud really started, and I was defrauded. So please explain a little bit.
What happened is back in 1933, when the unauthorized act of Congress changed our monetary system, it also put everything up as collateral. So they made a claim. All the governors went to Washington, D.C., and they made a pact called the Declaration of Interdependence, where they made a claim to all the land and said that everything belongs to the state. Okay, and so what they did was lands, it transferred or transitions in meets and bounds description. So what they did was they put up all the land and put it into two trusts. One was in the Department of Agriculture, the other was in the Department of Interior, and that's what it used to be the Land Management Bureau, but now it's the Bureau of Land Management, is the trustee over. And so they came in on the regular surveyor's map and they did an overlay, and they copied it on a special map. It's called the assessor's map. And it's an overlay over the surveyor's map, and instead of having the original lot numbers or whatever, however they were described at that time, they became parcel numbers, and it became the assessor's parcel, so it can never be yours, and it's a fiction from the gate.
Thank you so much, Doug. So when I found out all about this, I also had to research how to fix this fraud, and I researched that I have to bring the existing land patent that's pertaining to my property forth in my name, and that's exactly what I did. And I posted it for 60 days for anyone to check my claim to that actual land that's secured under the land patent. And I posted it in the newspaper, Mission Viejo News, that's adjudicated for State of California, County of Orange. I posted it for 60 days. No one objected. No one made any claim. No one made any claim of interest. And I received an affidavit of publication, basically perfecting the land patent, which you can find in the attachment A of my court of record. Once I did that, I noticed the County of Orange Corporation with DUNS number and EIN number that my property was misclassified and unlawfully placed under commercial real estate, which it is not. It's a private land and dwelling, and that they need to correct their records for fraud and remove it from their tax roll. They sent some communication, but really what happened was they didn't do it. So I defaulted them. I filed a criminal complaint. I torted them, and when they realized that they cannot extort these funds from me, they commissioned my mortgage company, Freedom Mortgage, to basically become their tax collector, their property tax collector. So I let the respondent, Stanley C. Middleman, know that this is unlawful, that I do not owe any property taxes, that I did not consent to open any escrow out of which they should be paying County of Orange. And as I was going through this process, their agents were basically telling me, no, we have to collect these property taxes. So we had many phone calls with them, which by the way are recorded. So it's a part of my record. And it went on for several weeks. So then I sent them a lawful notification, which is an attachment B, letting them know that they are not licensed governmental agent to collect property taxes. I did not give a consent to have these property taxes paid. And if they do pay them, it will be a gift on their behalf to the County of Orange Corporation. And also, I found out that there is a concern with the loan, that I would like to perform forensic audit on the loan, because I don't actually believe that I was loaned anything of substance of theirs for there to be a legitimate loan. So that you can find through the affidavit B, which was served with certificate of service. Since I did not receive any confirmation, any information, I served the respondent with writ in the nature of discovery and disclosure, and I started to ask specific questions in regards to the alleged loan, to basically prove that they loaned me something of substance, they're an asset that I took full custody, care, and control of, for there to be a loan by definition. So I asked them for the original promissory note marked with the proper account. I asked them also for the bookkeeping journal entries associated with the loan, the insurance policy that needs to be in association with the loan, deposit slips, and basically to provide the verified evidence that I actually was loaned something of substance of theirs, that I took full custody, care, and control of. So you can find that in attachment C. With that also, I served memorandum with points and authorities, basically explaining, as Doug Heisel was mentioning a moment ago, that the people no longer have money of exchange, that through this unauthorized act of Congress, we have no substance to pay for anything, that the only thing we have is money of account. And in this memorandum, which is part of that attachment, it explains how so-called money is really created in this moneyless society, that it's all done through commercial liens placed, and which is now as used as currency and negotiable instruments, and that we have only creditors and debtors in our society. And it basically explained to them all the details about the Uniform Commercial Code, how this money system really works, and if they have any comments, any objections, to rebut it. And they were provided 21 days to do so. It was signed by me, the woman, with three witnesses here, and it was served via certified mail, and it was received and signed for by Ortiz King. Then, when I did not receive a response to them, I served notice of liability and opportunity to correct and contest acceptance, giving them 3 additional days of grace period. And in that notice, I also informed them that they are a licensed, they are doing business as a licensed agent under state of California, a corporation which uses authority, their scope of authority, the 1879 California Constitution, which was repealed on November 8, 1960, and that I will need an evidence that this 1879 state of California Constitution has been reinstated for them to have any authority to do a valid license to actually be able to do business on California. And also that they need to provide me proof that I have a contract with County of Orange Corporation, that my property is not a private land dwelling secured under the mentioned land patent, and that it's not a system of constructive fraud, and that they entered into a chain conspiracy. So there is that definition, chain conspiracy, with County of Orange, that they agreed that they will become literally their thugs and start collecting property taxes that I do not owe on my private dwelling, and that basically what they are charging these property taxes is mere use tax, because I continue to be considered as a tenant. So that was served to them with certificate mailing. Then I sent them a lawful notification that was actually served through my witness, Doug William Heisel, who I commissioned to go and look for that APN number on my private dwelling. He was very successful, as he worked for surveyors firm, so he's very familiar with surveying the land and meets and bounds and everything like that. So he was able to locate the APN number that's been trespassing for all these years on my private land, and he put it into a package and sent parcel and sent this parcel back to the assessor working for the County of Orange, the corporation, who it belongs to. And also I like to mention in this case is that because of that deed of trust, and because the bait and switch, that's the only interest that the respondents, any of their agents and assigns like Fannie Mae and all this trust that they created around that constructive fraud, has only interest in. I, the living woman, Californian, one of the people, own the land in the meets and bounds description. The only thing they have interest in is in this APN number, that parcel, which is the overlay over the actual land, which was returned back to its owner, County of Orange, the assessor. And here we have the lawful notification that was autographed by 3 witnesses. It was received by County of Orange, duly signed for, and we also received a confirmation. We received a letter from them that they got it. So now it's in their possession. So this is very important, ladies and gentlemen of the jury, that you take notice that APN they are referring to in regards to my property is actually back with its lawful owner, the assessor's office for County of Orange.
Yeah, they were kind of surprised. They thought the parcel included like a quarter acre or whatever, and they got it back and found it out it was only like 2 by 8 acres.
So based on that, I served the respondents with notice of fault, opportunity to cure, and contest acceptance, basically stating that they still have 3 days of grace period to respond and rebut anything they do not agree with in regards to the loan, in regards to being a licensed governmental agent to collect property taxes. And it was received. Let's see when it was received. It was received and duly signed once again by respondent agent Otis King, And also, my notice of notice to cure included my fee schedule. Should they continue with their trespass, this is what they are agreeing. This is my fee schedule, and all the fees are stated here. And should they not correct their actions and their wrongdoing, this is what they are ordering from, which was once again was received and contractually accepted by the respondent and his agents. As the honorable woman I am, I continued to give the respondent the opportunity to provide the evidence that I was actually loaned something of substance of theirs that I took full possession of. And so I served notice of adequate assurance and of due performance, which also includes affidavit of Walker F. Todd, who is the expert witness in monetary and banking instruments with 20-year experience as an attorney and legal officer for the legal departments of the Federal Reserve Banks of New York and Cleveland. And since the borrower paid money in the form of promissory note to the lender to perform according to the loan agreement, the borrower is now hereby requesting adequate assurance of due performance pursuant to their own uniform commercial code section 2609, that the lender has performed according to the loan agreement, and that the original lender used their own money to purchase the borrower's promissory note and did not accept the borrower's promissory note as money or like money to fund the check or similar instrument that the lender then lent to the borrower, which would have an economic effect similar to stealing, counterfeiting, and swindling. And so it also included an affidavit of Lenka, where under pains and penalties of perjury, I did swear that I gave them the promissory note, which was not a gift, and an exchange is not a loan. And it was duly signed, autographed by me in front of notary public. And I asked them to do the same. I asked the respondent to do the same. Please give me your own affidavit under pains and penalties of perjury, stating that you did actually gave me the loan for $360,000. And the respondent refused to do so again. Okay, so you can find all the evidence in attachment G. Since the respondents failed to rebut, I served them with affidavit of default and final judgment res judicata, which you can find under attachment H, which basically states once again for the record and on the record that they are agreeing, stipulating, admitting, and confessing to that they did not make me, that they did not give me anything of substance, any asset of theirs that I took full custody, control, and care of for there to be a definition. Okay? And that was served once again via certified mail. I did this affidavit under pains and penalties of perjury in front of notary public with a jurat right here. And once again, it was received and contractually accepted by the respondent and his agents by Otis King via certified mail. Well, now I had it on my record that I'm dealing with criminal enterprise. The first assumption was that they are operating with in good faith and clean hands as they presented, but through the defaulting process, they prove otherwise. So now I'm dealing with criminal, and I'm in a hot pursuit of a criminal. So I had to file a criminal complaint with U.S. attorney And this is following an order, presidential order. This is President Trump's order number 13844 of July 11, where task force was established, which is called Task Force on Market Integrity and Consumer Fraud. So I am a consumer who got injured. And it is my not only right, but my duty to report this criminal act. So I filed criminal complaint with statement of facts under penalties of perjury, with argument and points of authority to support that criminal complaint, and also with arrest warrant, because now we are dealing with a criminal. And that you can find in attachment I. Yes.
What happened is these mortgage companies, they don't want to deal with people. They try to hide everything because they don't have what's necessary to verify the loan, because they never made you the loan in the first place. The reason that they can't verify the loan with the original note is because the original note was deposited in some depository institution and they have it. And so since we know this, and we know that her credit had been loaned back to her as a loan, we tried to get them to give us the information and the evidence, but they couldn't do it because they don't have it, and we knew this. So they have a assumption and presumption of operating in good faith, okay? And so if you have to take that away from them. So she tried 3 times to get them to give her the evidence, or at least do an affidavit showing that they loaned her something of substance to actually consist of a loan by definition. See, a loan consists of, if you call me in and say, hey, I want to loan you some money for this right here, and I say, okay, and you give me some money, gold, silver, or something that's backed by gold and silver, because that's what money is. If you give it to me, and I take full custody, care, and control over it, meaning that you don't have any say-so of how I spend it or anything, but once it's in my hands, I now owe you. So I do a promissory note at that point, promising to pay you back with interest or whatever we agreed to, because you actually gave me something of substance. That is the definition of a loan, okay? These people never gave her anything of substance. They gave her her own credit back, and all they did was basically a banking transaction. They're not going to cop to this. So they're not going to give you any evidence. They're going to keep giving you the same copies of the note and a stack of papers of your closing. None of that matters if there was no loan, okay? So what she did was she presented 3 different times to him and gave him 3 different opportunities with a grace period to go ahead and provide her with the documentation to verify that there was an actual loan, and she would gladly pay it. But she did an affidavit saying that she did the note, the promissory note, which has a monetary value, and she was never given anything for it. And they still wouldn't respond. So she did everything that she could and then defaulted them. So the law is, if you don't rebut, you admit. So they admitted to everything that was in there, and she even sent them a notice of what they were going to be admitting to, and they still went ahead and admitted to it. So they had every opportunity, and now they're operating in bad faith. Okay, it goes from their presumption and assumption of operating in good faith to now there's evidence that they're operating in bad faith with guilty knowledge. And so based upon that, once she defaulted them, it locked those facts in. They agreed to those facts, and based upon those facts, they committed a crime. So based upon that crime, she had to file a criminal complaint, because what that does is it takes the assumption and presumption of their bad faith out of the pocket and out of the game, and it turns them into criminals. It also bonds the complaint or anything that she does after that, because now there's no liability or there's no libel, because they've proven themselves to be criminals, so you can't libel them by calling them that. And so I
Thank you, Doug. And also, when I finish with presenting these, my code of record, I will be playing you an evidence of one of the phone calls, which basically proves that they have this whole enterprise set up of thousands of employees working, and they never provide their last name. They just run you around. You never speak to the same man or woman again, and it's done on purpose. You know, you hold for an hour. These conversations take usually hour and a half, and it's designed that way to exhaust the consumer, exhaust the people, to just make them to give up. So based on that, I asked, and I've the witness, I asked a notary for notary public to do a notary presentment as a one last chance for them to do the right thing and provide the evidence that they loaned me something of substance, that they made me a loan, and they defaulted on that too. They were also provided a notice of opportunity to cure and correct. They failed on that too. So that's in attachment J, the notary presentment, and subpoena duces tecum. So then in attachment K, I proceeded to tort. As Doug mentioned, you know, the criminal complaint bonds the tort, and that was served on respondents and with a true bill. With a true bill, that true bill in commerce, that comes to $6,645,000 to be paid in 1 ounce silver coins, and it's published signed with a witness here. And I also issued a bill with my autograph and my seal, and this was served on the respondents, and it via certified mail, United States Post Office certified mail, which was received and contractually accepted once again by Ortiz King.
There's we know who the mailman is.
Yeah, we know who handles all the mail. In attachment L, you will find notice of fault, opportunity to cure, and contest acceptance. Basically giving them another opportunity to cure and contest acceptance.
3 days grace.
3 days grace, which actually is served by the notary public.
And notice what they would be admitting to.
And notice what they will be admitting to, and any injuries to be paid damages, and they didn't correct, and so an affidavit of default and final judgment was served to them. It was received, and here we have a proof of that receipt. So with that first billing, they were provided 30-day period to pay for what they agreed on the injuries to be paid in the damages, and refuse or reach out to me and make payment arrangements, and they refused to respond. And so I served them with a past due notice and second billing. Once again, received and signed, contractually accepted by Ortiz King. Because I'm an honorable woman and always want to make sure that I give the people I'm doing business with as many opportunities to correct and to settle the matter. I also serve them with verified good faith offer to pay to basically settle any of the alleged mortgage debt, asking them what species they would like to be paid, which also included, it's quite large. I made that verified good faith offer under pains and penalties of perjury with in front of notary. And I also send them I placed the lien because I wasn't paid within the 30 days. So it was I sent them a copy of the lien, which was once again received and contractually accepted by Otis King, the respondent. And I still wasn't paid after the 30-day period. So I sent the respondent, third final notice with a bill here. And I also let them know that at this point, I'm also sending lawful notification and putting the stress on oath of office of the sheriff of County of Orange Corporation, just to ensure that there is no trespasses going on, any harassment, any intimidation, as we many times hear about. So that was a respondent along with the final and third bill via United States Post Office as a federal witness, and it was received and contractually and duly signed by, once again, respondent, but someone else, Thomas Emerschet, someone like that. Mm-hmm. Okay. You actually have you actually are receiving a copy of the distress and lawful notification via attachment P that I served on the sheriff of County of Orange. Yes. And it's along with the recorded, recorded. Okay. And yeah, there it is. And it was done under pains and penalties of perjury with in front of notary. It was read. It was received. It was sent actually hand to hand via registered mail, and it included the recorded lien, which I recorded on California Republic. And I also, the honorable woman I am, and to stay in honor, I also offered that we can settle any of the alleged debt via UCC 3 partial assignment when I assign a portion of the collateralized debt obligation that I achieved through the 3 billing cycles, which perfected my accounts receivable, that if they can prove that they loan me something, that I'm here ready to settle that alleged debt via this partial assignment. Okay, I sent another copy of the partial assignment just to make sure that they received it, and I received a letter back from the respondent. And notice again, customer care team, all right? No man or woman putting their signature, no full name, no one taking responsibility. But in this letter, they are telling me that they cannot accept my UCC partial assignment. Let's see here. That is some kind of legal theory, and it is that I'm attempting to do debt, that I'm trying to avoid a debt and eliminate debt. And I believe that in one of the letters they were calling me that it's an attempt of sovereign citizens, so trying to attempt to libel me. Okay? So this letter alone serves as a discharge of the alleged debt, because it's their rejection, which according to their own law, Uniform Commercial Code, UCC 3603, tender of payment law. If that presentment is if that payment is rejected, it's discharged.
for that amount.
For that amount. So right there, which is attachment Q. So in attachment R, serve the respondent with notice of discharge, letting them know, well, thank you for the confirmation that you rejected my payment in accordance to tender of payment law. If tender of payment of an obligation to pay an instrument is made to a person entitled to enforce the instrument, and the tender is refused, there is discharge. There is discharge right there. UCC 3603. I sent them notice of liability once again, and I also included, because they were making all kinds of statements and using some case laws, which does not even apply. I also included the case of Jerome Daly, which goes over everything that we are dealing with, and it's been already ruled. Do you want to maybe mention something about that?
Jerome Daly set a precedence about the fact that money was no good, and nothing of substance was loaned, so there was never a loan made. And then you sent him the affidavit of Walker Todd, which basically explains the whole monetary system as it exists after 1933. So basically what she's done is she's held her court of record. And what that means is it's her administrative process, her private administrative process, because we're private. So what we do is we give them every chance that they, that you can give them, really, to give them the process that's due to them, to allow them to correct the situation. Or what happens is, if you do it like she did it, it's all a matter of public record. The stuff's with the notary, it's documented. It's a matter of public record that they got it. So their actions after they get it either acquit them or convict them. And you can't argue with public record. Hey, if you've got this and you ignored it, that's on you. That means that you don't know what your duty is to we the people, okay? And, it's our problem too, because we haven't been holding these people liable. They look at our paperwork and just kind of shuck it off because most people don't follow through, or they haven't done it right, or they don't lock them in properly. And now the only remedy that we have is our court right here, okay? This is where they've admitted, confessed, and stipulated to everything by their acquiescence. They were even told what they'd be admitting, stipulating, and confessing to. And they've got just so much disregard for the people, and they think that they're public leaders and public tyrants is what they think. And so what they did was they put themselves in a box, because even their own public policy says if you don't rebut, you admit. And they use all this stuff against us all the time. Well, we hold all the power, people. We delegated them the power and the authority through the Article 3 and in the states to put together these court systems, okay? But it's our authority that we delegated. We can't delegate authority that we don't have. So we have a right to hold our own court, and that's what she did with her paperwork. I know a lot of people think it's tedious, and it's definitely not going to be spending a headache. But what you have at the end of it is you have their admission and confession if they're crooks. Because when they don't do what's right and they don't correct it, such as their fidelity bond, which is their oath to serve with fidelity, if they don't correct it, well, then they're acting outside of their delegated power and authority as a bunch of criminals. And they're corrupt. And we don't really want people to work for us, and they work for us.
Thank you so much, Doug. So after all of this, and them confessing, admitting, and stipulating to everything that I presented to you, they continued with their criminal enterprise and their harassment. They sent a letter saying that my account has been changed and has been referenced to foreclosure. And you will find that in attachments S, to which I responded with notice of liability that now they are libeling me and that I have the right to due process, that because they were stating that they basically do not need court order because they recorded this. They hired a law firm called Idea Law Firm out of Nevada, Las Vegas, and they recorded the default of the alleged mortgage with County of Orange and notice to sell. And from there on, my family and I, we've been harassed with phone calls, with text messages, with letters, trying to offer help and remedy, okay? And that's all noticed in the attachment T. And I've also included the last and final notice of the that the only debt outstanding is their agreed injuries that they caused to me and my family, and to be paid in the damages. And it was received. It was certified mail and received. I have the confirmation right there, which you will find in the attachment T. Now, if you will allow me, I'd like to play you one of those calls, and I like to remind you that we've had these calls for over a year, and on most of the calls, Doug was a witness. And so let me minimize it here, and let's see if we can play it. And in this short phone call, I like to demonstrate the system of constructive fraud, what they created to ensure that it seems like they are trying to help you. It seems like they are so lovely and nice people, but they've created a system of constructive fraud and chain conspiracy to basically defraud you through the way how it's all set up, okay? So let me just move these screens next to each other, and I will have to pause when I'm mentioning my Social Security for privacy and confidentiality reasons. So and please let me know if you cannot hear it for some reason, okay? Because I'm playing it on the same device here.
Thank you for calling Freedom Mortgage. My name is Liani, teller ID 3681, with whom I have the pleasure of speaking with today.
Yes, good morning. And what was your name? I'm sorry?
Liani.
Hi, Liani. My name is Lenka Coloma. And I put in my loan number. Do you need it again?
No, can you verify the last four of your social?
Okay, I need to pause it a little bit.
I can provide you with my ID number.
Okay, it's kind of a little bit strange, isn't it? Because you have my full name, you have my Social Security, you have access to my financial information, you even have address where I live, and you cannot provide your last name. What's the reason?
No.
I'm sorry?
We don't have to provide our last names.
Well, I really do need someone with last name because we have quite issue with this alleged loan, and so someone will have to be held responsible and liable because I will be subpoenaing you, and I need to know who the living men and women are who is taking liability for this. So would that be you?
No, I'm sorry. I'm not going to provide my last name. Give me one moment.
Thank you. Okay, let me
No
pass
problem.
forward.
So I have just going to be able to assist you.
Okay, thank
Again,
you.
thank you for calling Freedom Mortgage. Good afternoon. My name is Haley, teller ID 1546. I'm a supervisor with our loss litigation department. How can I help you today?
Yes, good afternoon or good morning, Hailey. This is Lenka Coloma, and can I have your last name, please?
No, we do not give out last names. We only give out our first names and our teller ID.
Okay, and isn't, this is kind of strange because you have my last name, you have my social security, my financial information, you even have my address where I live. So is there a reason for that?
It's company policy as to the protection of our agents and our internal employees so they are not harassed or separated. Anything at a larger scale would have to be done with the company themselves, but we do not give out last names.
Okay, and why would you be harassed or for security reasons? Like what's going on? Because I have customers and they know my full name, and like why? I'm just really finding this kind of very concerning. Don't you?
I understand. Unfortunately, it is company policy. We do not give out last names.
Okay, well maybe you should bring it up with your principal, with your boss, because I'm actually, the reason I'm calling here is because I've sent notice of actually, first of all, I received a letter using United States mail threatening with foreclosure, while you guys never provided an evidence that you loaned me anything of substance of yours that I took a full custody, care, and control of. And now you are using United States mail to threaten me, not only me, but my family. You send it to the address of the property, which you don't even have interest. So this is why I'm asking for the last name, because I will be sending subpoena and I need to know who I need to hold accountable to the system of constructive fraud and also mail fraud. So is that going to be you?
That would not be me. That would be Freedom Mortgage as a whole that you would direct us to. And it looks like the foreclosure was proceeding as of August of this year, as we sent out multiple breach letters to advise of pre-foreclosure proceedings.
Well, okay, yeah, I that's what I'm calling about, and I need to know who sent that letter specifically. Okay, using U.S. mail, because as I said, you did not provide the evidence that Freedom Mortgage gave me something of substance of yours that I took full custody, care, and control of, or there to be a loan by definition. Okay, and you've defaulted on that. There has been a criminal complaint filed with the U.S. Attorney's Office. There has been a complaint filed for counterfeit securities with the SEC, and the list goes on. I have about a 5-inch stack of court of record. So the reason I'm calling now is to find out who actually sent that letter dated August 1st and it was August 1st. So I need to know the name, the full name of the man or woman who will be subpoenaed to answer to that. So is that going to be you? Because
Letters are automatically generated from the system. They are not generated by an individual.
Okay,
you would have to
who did
utilize the Freedom Mortgage as a whole. There is no individual person for that.
So it's a policy.
So it's a policy. So I'm dealing with like a fiction that just basically creates these letters and then uses United States Post Office to threaten, coerce, and intimidate.
We also like the policy. What policy number is it that they can't say their name because we need to subpoena that?
Yeah. I need to know the policy reference or information which instructs you that you cannot provide a last name because you all people will be subpoenaed, including your CEO.
That is an internal policy. There is nothing I can give you on that. And all of our correspondence regarding monthly billing statements and all of that goes through the U.S. Postal Service.
Right, which is mail fraud.
Which is mail fraud.
Okay, so you basically cannot provide your last name, so we can just go with by your ID number, which was, what was your? Well, so you have the taste of the level of criminal enterprise we are dealing with, and we have year worth of phone calls similar to this as an evidence. At this point, I would like to call my witnesses to the stand, if I may. So the first witness I like to call is Douglas William Heisel.
I have a question.
Yes.
Do we have all the jurors on, or did someone leave? Is everyone on the jury still here, or did someone leave?
I'm sorry, I was muted. Yes, we still have all the jury members here, and we can verify once again in case there's been any technical difficulties.
And you have alternates are there also, so they're listening?
Yes, we have 2 alternates, and that's a very good point, Justice Barbara, Susan. What we'll do is, what I will do, just in case there was technical difficulties, I'll do a roll call for the jury members again. Let's ensure that we do have all the jurors on here. So let me do that roll call real quick here. When I do call your name, please give me a present or here. Unmute your mic and do that and raise your hand as well. Foreman for the jury, Janet Harden Waldlow.
Here.
Curtis Timothy Keller.
Here.
Willie Allen Jones Jr.
Here.
Paul James Koppak.
Yeah.
Michelle Lynn Morissetti.
Present.
Jean Bright Isato.
Present.
Todd Allen Mitchell.
Present.
Laura Diane Mitchell.
Present.
And Darcy Diane Raymer.
Present.
Brianna Jaden Need.
Present.
Susan Marie Casciato.
Sandra. Present.
Sandra. So thank you for the correction. If I do enunciate your name or something, the correction will be noted. Thank you. Melissa Ann Nicole Peters, alternate.
Present. Nicolau.
Nicolau. Thank you. Pamela Joan Parker Papa. alternate.
Present.
Thank you. All juries or jury members are present and accounted for.
Only John Lumiere.
John Lumiere wins present.
Oh, I skipped over your name. Thank you very much, John. So that does conclude. We have all 12 jury members and 2 alternates still on the call. And with that, I will turn it back over to Lenka.
Thank you, Tony.
I just have another question.
Yes.
I'm sorry, before you move forward, is it all right if I ask a question?
Yes, just state who you are for the record, please.
Susan. This is Susan. Justice Susan. When you got the letter from the APN where they sent you back a letter, is that in your evidence files?
Yes.
Okay. And are you working with a bank, or were you working with a bank on this?
Meaning no.
Okay. Did you ever consider taking all your documentation and putting it in as a special deposit to a bank and having their legal department move this through to the Treasury for you?
No.
That might be
The next one on this.
okay. I just wanted to make sure, because once you have this as a finding, you can put it and back it and send it to the Treasury for them to liquidate and go back in and collect on this.
Yes.
Okay, just wanted to make sure.
Thank you. Thank you, Acting Justice Susan. All right, so without further delay, I would like to ask and call Douglas William Heisel to the witness stand. I believe it has to go through Tammy, our acting.
Doug William, yes, sorry. Doug William Heisel, please raise your right hand. Do you solemnly swear to tell the whole truth and nothing but the truth, so help you God?
You.
You may proceed to Lenka.
Thank you so much, Tammy. Doug, how long do you know me?
About a year and a half.
Okay. How did you come about to know me?
We were standing up the Republic.
Great. And do you recall being attending to when I was making all these notices and serving the respondents.
Yeah, I've been your next friend and helping you on all of your litigation for over a year and a half.
Yes, thank you. And do you recall when I asked you about finding the APN number, and if you do, to send it back to the assessor's office?
Yeah, I went out and found it, put it into a padded envelope, which constitutes a parcel, and we sent their parcel back to certified mail. Returned it to its proper owner, since it wasn't actually really a part of the land.
Thank you. And do you recall when I was on the calls with the respondents, and we made, I don't know how many phone calls over the period of 1 year?
Yeah, we made numerous phone calls to Freedom Mortgage. Each one of them took about an hour or longer. The way that they have their program set up, in my opinion, is they know that what they're doing is wrong. They've got the knowledge of guilt because they have their employees hiding their last names so that nobody can be held personally liable. And they've got, what do you call it, plausible deniability. And in the whole year that we called them, I think we talked to one agent twice, and that was it. So you never talk to any of these agents twice. You have to explain everything to them at the bottom level. And when you get about a quarter of the way through it, their ears start smoking, and they go, well, I got to send you to a supervisor, escalation specialist. And they have all these weird names, like Consumer Care Task Force or Consumer Care Team, Escalation Specialist, Supervisor of Candy Bars or whatever. And, you explain it to one person and they send you to another. So you got to explain it to them again, and then they send you to another. And then you got to explain it to them again. And then they say, well, they're going to check into it and they'll get back to you, or they either hang up on you. And then you got to start it all over again. They never give you their last names. They can never remedy anything. None of them ever have the authority to do anything. They have to always talk to somebody else, and it's just a big runaround. You never get any relief or any decent information. Okay.
Did you feel exhausted from it and frustrated from it?
Well, actually, I thought it was kind of funny because, by the time we got done with the calls, they're the ones that felt exhausted and frustrated.
Right. But it was year and some worth of calls and hour each time because, like you said, just being pushed around.
I have a question. This is Susan.
Yes.
Did you ever ask to speak to their legal department?
Yes, we did. And matter of fact, they brought their legal department up once, and we said, good, can we please speak to them? And they said, we can't give you that information. I believe that's one of the ones that they hung up on us.
Yep, they hung up on us.
Okay, my question is, they didn't give you the legal department's name and number that you could contact them, or they didn't give you the information you wanted?
Both.
So you don't know who their legal department is?
Nope.
Oh, that's interesting.
We even tried looking it up.
Yeah, I believe that one of the letters
went. Go to the Secretary of State and ask them to provide their legal department.
No, this is in what state is this?
No, it's what happened is then they hired a law firm out of Nevada to basically handle the foreclosure.
Okay, but they hired a different law firm. They don't have their own attorney operating. Is that correct?
What they told us at one time was they had this legal department, but they couldn't give us the address or the information just to send it to what was the headquarters, right?
Yes.
Send it to the headquarters.
Okay, so
We
you
said,
can
okay,
go
well,
to
who
the
do we
sec-
address? Who do we address? What's their name? And they wouldn't give us a name or anything else when we kept pushing it. I believe they hung up on us.
Yeah.
Can you go to the Secretary of State and get that information from them? Because I believe they have to have it when they registered with the Secretary of State. They have to have that information. You might look.
Yeah.
They have an agent registered for service. That's it.
And that's who we also used. Anyway, thank you so much, Doug. I would like to now call the second witness.
Thank you, Doug Heisel. You are dismissed.
Oh, excuse me. This is the acting sheriff, Anthony Lewis Fernquitos. I believe, Lenka, now the court proceedings actually to have asked the jury to see if they have questions, and if they do, the questions would be forwarded to the foreman to be able to ask the questions of the witness. So before we dismiss, Tammy, if you wouldn't mind, I'm sure, Lenka, you could ask the jury if they have questions for the witness. If they do, Tammy will need to swear the witness back in.
Thank you, Tony. I would like to call my second witness, Paul Edmund.
Ask questions.
Oh, sorry.
You need to ask the jury. Lenka, please ask the jury if they have questions, and the questions will be relayed to the foreman via chat, and they will ask the questions if they have any. So please ask the jury if they have questions for the witness.
Yes, ladies and gentlemen of the jury, if you have any questions, please go ahead and give it to the foreman of the jury at this time. And
if there are questions, then Tammy will need to swear the witness back in because she had dismissed the witness. Let me see here. I'm looking for Jeanette. Does the jury have questions for the witness?
I do not have any questions asked at this time. I do not have any questions asked at this time.
Thank you.
okay, thank you. So I can keep calling my second witness.
Yes, Tammy has already dismissed the witness, so he remains dismissed. You're able to call your second witness.
Okay, thank you so much. I would like to call Susanna van Groenen, my second witness, on the stand.
Susanna.
Susanna.
Yes, I'm here.
Susanna.
Oh, there she is. Hi,
sorry.
Susanna. So Tammy, back to you.
Susanna von Grunen, please raise your right hand. Is she there?
Yes,
Okay. Do you solemnly swear to tell the whole truth and nothing but the truth, so help you God?
I do.
You may proceed to Lenka.
Thank you.
Thank you so much. Hi, Susanna. Great to have you here. Susanna, how long do you know me approximately?
I would say going on 3 years now.
Yeah. And how did you come about to know me?
We met through the California Assembly.
That's right. And Susanna, do you recall when I commissioned you to do the notary presentment on the respondents?
Yes.
Okay, so you did the presentment, then you did the notice of a notice of fault and opportunity to cure contest acceptance, correct?
Yes.
And then when they failed, refused to respond, you did the affidavit of default.
Yes.
Okay, excellent. Thank you so much. And you are the notary public for the state of California, correct?
Not anymore, but yes, I was at the time.
Yeah, and now you serve as the public notary, republic notary.
Yes, I've not really done much with that, but I'm waiting stamps and stuff for that.
Great. Thank you so much, Susanna. That's all we really needed to know.
Please ask this is Anthony Franquito, acting sheriff. Lenka, please ask the jury if they have any questions for the witness before she's dismissed.
Jury, do you have any questions for the second witness?
Jeanette, the foreman, I'm addressing, this is the acting sheriff, once again, acting the foreman of the jury. If she's seen anything in the chat or have any questions from any of the jury members.
No, there are no questions from the jury members.
Thank you.
Thank you.
Excellent, thank you. So if I may.
Sorry.
Tammy has to dismiss me.
Thank you, Susanna Van Brunen. You are dismissed.
Thank you.
Thank you so much. And I would like to call my third witness to the stand, Paul Edmund Gilbert, please.
Speak here.
Yeah.
And look.
First look there, because you got to be sworn in.
The question is?
Hi, Paul.
Yeah.
She's gonna swear you in. Oh, swearing me.
Okay, Paul Edmund Gilbert, please raise your right hand. Is it raised? Okay. Do you solemnly swear to tell the whole truth and nothing but the truth, so help you God?
I do.
You may proceed to Lenka.
Thank you so much. Hi, Paul.
Hi, Lenka.
So Paul, how long do you approximately know me?
I've known you for a little over a year now.
Great. And how did you get to know me?
I got to know you when I was introduced to Doug Heisel, and subsequently was sworn into the office as a court clerk.
Yes, great. Thank you. And as the recorder, you recall that you received some of the documents from me on the respondent, such as the lien that I filed through your office as acting recorder for California State Republic and acting Secretary of State.
Yes, I have received multiple documents from you, and I saw the attachments, the exhibits that you presented here on this court as being documents that I have received and recorded and have copies of.
Okay, great. Well, thank you so much, Paul. That's all I had, all the questions for my witnesses. So back to you, Tammy.
Thank you.
Please ask, Lenka, please ask the jury to see if they have any questions for the witness.
Yes, jury, do you have any questions for my last third witness?
I do not see any questions.
And that was who's speaking? Yes, Jeanette, the foreman of the jury, states that there are no questions from the jury.
Okay, thank you so much.
Thank you, Paul Edmund Gilbert. You are dismissed.
Okay, ladies and gentlemen of the jury, that concludes my presentation of my code of record. As I mentioned, everything has been posted and is available for your review, and I greatly appreciate your time and attention to my claims here. Thank you so much.
All right. Anthony Louis Franquito, the acting de jure sheriff of Nevada County for this court of record, Lenka Columbus Court of Record. I am going to ask one more time, give a final call out to the respondent's agents to see if they are present. Is the respondent or respondent's agents present? For the second time, is the respondent or respondent's agents present? I see no hands raised. I see no voices. Nobody's chimed in. I see nothing in the chat. Okay. Okay, and for the third and final time, is the respondent or respondent's agents present? Okay, I'm looking at the videos, and I see no hands raised, and nobody is speaking, and there's nothing in the chat. The respondent or respondent's agent are not present and forever waive their right to speak and present evidence in this matter. At this time, I'll turn it over to Lenka. Yes, Lenka presents a true bill in order at this time. For me, if she would present that to me, the acting sheriff, and I will present that to the jury. And as of now, the jury members may leave the Zoom meeting and go to the GoToMeeting link because we are breaking for deliberations. We are now breaking for deliberations. The jury shall leave this meeting, the Zoom meeting. People are allowed to stay here. The general public can stay on. I'm sorry, Lenka, you have a question?
Yeah. Can I just have, and my next friend, Doug, just say final closing words?
Sure.
Thank you.
Look, what we've done is we've presented the facts, and the whole thing basically turns on the fact that there was no loan. Okay? And if there's no loan, then there's nothing after that. There's nothing, all the rest of the stuff that they try to come up with and everything else is just something to get you to chase off of the root cause. So when you look at this, and they don't give you the evidence that they didn't loan you anything, what you have to do is you have to look at everything that was presented to them and know that these people have a duty because you're a customer, and not only that, they have to operate in good faith. If they don't operate in good faith, then they shouldn't have a license to do business. So what happens is you give them 3 chances to verify the loan. The loan has to be verified under TILA, under the Truth in Lending Act, okay? And verification usually means under the penalty of perjury, okay? Not just them giving you a copy of the note, which is a securities fraud. It's a counterfeit securities to make a copy of the note and pass that down the line. So what we need and what we've shown here today is the fact that they never loaned her anything of substance of theirs to constitute a loan by definition. What they did was they conned her to come in, and through sleight of hand magic and wordsmithing, they got her to do a promissory note when they didn't give her anything. You're not supposed to do the promissory note until after you've actually been loaned something of substance and you've had it in your hand and done something with it. Okay, that is a loan. So this is what everything hinges on. And that's, this is constructive fraud. It's built into the system. And this is what we are really pinpointing everything on today. So when you look at this and you go in and deliberate on this, I ask you to look at the facts that there was nothing of substance ever loaned, because there is no substance since they took all the substance from the monetary system. And this whole system is founded on constructive fraud, founded on the fraud that they took all the substance from our monetary system, okay? And what we need right now is these facts to be found by this jury and unanimously, and to be cemented in stone, because these facts will never be able to be reviewed by any other court, okay, except by common law, and that's going to be impossible for them. So they're not going to be able to appeal this. This is what time it is with us coming after these loans and this fraudulent system that they put in place. This is our way of rectifying the situation. This is our remedy and relief. And so I thank you guys, and I thank you for everything that you've done.
So one more time, when there was no loan, there is no mortgage. If there is no mortgage, there is no debt. If there is no debt, there is no foreclosure.
No RESPA.
No RESPA, no Fannie Mae, no REIT, none of that. And with that, I would like to conclude my court of record presentation. Thank you so much.
I have a question.
Okay.
This is
Who's
Susan.
speaking?
This is Susan.
Thank you.
Did you ever pay them back anything of substance?
We did. What happened was we put a lien on all of their tangible property, and we used that to securitize the debt when they didn't pay. And after the third and final billing, it turned into an accounts receivable that turned into a collateralized debt obligation, the same as a mortgage, only we had their house and cars and everything that had a title on it put up as collateral. And so what happened was we used that collateral, which is substance. She did a UCC3 partial assignment collateral to go ahead and pay the loan because, pay the alleged loan because she's operating in good faith.
I think you misunderstood my question. I think you misunderstood. Doug, I think you misunderstood my question.
Okay.
When you originally got the purported loan, and you say they never loaned you anything of substance, when you were making payments on that loan, were you using the same substance that they loaned you to pay them back with? Were you using Federal Reserve notes?
She was using
international units.
She was using, I believe, transfers from her account, and she listed all of the money in her account as lawful money with the bank.
Yeah, so all my money that's coming in and all the money coming out is lawful money, pursuant also to their own Title 12 USC 411.
411, yeah.
Okay, the reason I'm asking is because it seems like it was a trade for trade, same worthless paper for the same worthless paper. So that's why I'm saying it appears to be that, appear to be that. Does that make sense to you? Do you understand what I'm saying?
Well, yeah, it makes sense. But what's happened is there's collateral that's involved that they got the APN number, but they're trying to actually take the property.
Okay, but when they enticed you into making a loan, they got you to fill out an application. And there's certain things I've heard about that when you fill out an application, you're presumed to know what you're asking them for when you make the application for the loan, that it's not this whole constructive fraud. We're presumed to know that application applies and it's related to this whole monetary system that was altered. And most people don't. And in my opinion, that's how they scam everybody, and then when they come back with the presumption that, well, you knew what you were getting. And so there has to be, that's why you went into the fact that no, there was an alteration in the monetary system in America, and it shifted everyone, the entire population, into a maritime system of law, which is not even known to, half the attorneys don't even know what that is. And
Yeah,
so,
well, where it came in with her is they went and showed her a house and land and everything, and then she went in and she thought they were loaning her money. At this time, she had no idea about any of this, and thought they were loaning her money, and that she was using that to buy the house. She had none of this stuff was disclosed to her whatsoever.
okay,
And
so what that's called is the rule of discovery.
right.
And I didn't see that into any of your paperwork. If you use the rule of discovery.
Well, yeah, she put that into her explanation. She said that it took her a few years to find out.
Okay,
Just
and
what
there
happened.
is a specific rule of discovery, because they come in and say, well, you brought it too late. I went through this with some
Yeah,
others.
there's no statute of limitations on fraud until you discover it. That's the rule of discovery.
Well, the rule of discovery gives you 2 years to apply to correct the situation.
Yeah,
And
once
that's
you
why-
discover the fraud.
Yes, once you've discovered what the construction was that was deceptive, and it's exculpatory information that these other people were withholding, which makes it a felony for them to withhold exculpatory information. So these are all legal points and things that I want to bring in so that anybody that's listening can look it up on the, in the dictionary and see what it means to, what is exculpatory. It's information that should have been revealed that was withheld, and it's to your detriment. And therefore, that's a felony for them to do that.
Yeah, but it's also a felony for them to take and tell you that they're going to loan you something, okay, when they've got a monopoly on monetizing credit.
Right, I understand that.
And so then they come in and they get you to do a commercial instrument that has the monetary value of what this supposed loan is supposed to be. And they take that, instead of giving you something first, they take that and deposit it and then reconstitute that as the loan. That's usury right there. Okay, that's fraud and usury and everything else. They don't tell you that because. Well,
this is just for clarification. So
I'm just saying that this is where she started at, and then once she discovered the fraud, she went at them head on with it, and they don't want to deal with it. And then she pulled apart their little system with the evidence showing that they created their system to create confusion and keep people from finding any relief or any information.
And the only reason I'm asking this question is so that you can clarify those issues for the court.
Okay.
Right, and if they were acting in good faith and clean hands and come to me, hey, we have monopoly of monetizing your credit, and we will charge you 10% for getting these funds, this $360,000 loan, I would say, yeah, let's do it. And there will be full disclosure and meeting of the minds. They didn't.
And it would be a banking transaction, which is all it is. That's why they put it into a transaction account in your name.
And it would be fine and lawful and full disclosure and meeting of the minds, but that didn't happen.
Well, not only that, they didn't have a right to take the substance from our monetary system. So.
I know.
Okay, I'm just letting you know that then when they did that, when they removed the substance in America and they loaned it out to Europe after the war to help them rebuild, they were supposed to get that back, and we were supposed to get the returns on the funds that we had, and they never gave us the returns, but they gave it to the 44 federal judges. And all I'm saying is it's out there in evidence so that people can see if they look and follow what was actually done in America, because in America is unique in all the world of the system we have here. And we're being the beneficiaries, and they are trustees under trust law. They are the ones that have the liability and have the duties. And so that's what you're applying here. And many people, and I didn't know that this system was such in trust law. So that's all I wanted to make a point.
Yeah.
Thank you.
Thank you.
Tony, back to you. It's concluded.
Okay. Thank you. This is Anthony Lewis Franquito, the acting sheriff in Nevada County for Lenka Coloma's Court of Record. That's the common law court. And right now we are closing this court for deliberations, so the jury could now leave and enter the link for deliberations. I will present the true bill. Lenka will present me with the true bill and proposed findings of facts, and I will convene with you in the private link to present that, and then I will exit that meeting so you can deliberate. The jury members can deliberate in private. Nothing will be recorded. That is a private court deliberations. With that stated, I shall close this court record for now, and we shall stop the recording. And then once the jury lets me know, the foreman lets me know, then I will reconvene the court in this way. Thank you.